me. And good afternoon, ladies and gentlemen. It's a real pleasure to be speaking to you here. We've never worked with the Singapore Chinese Chamber of Commerce before, and this is the first time for us. So it's a very exciting opportunity, and we're very grateful for them to sort of organizing this, and grateful to you for spending an hour and a bit with us this afternoon. We're going to talk about, as the slide shows out, the title of our presentation is Resolving Cross-Border Disputes in a Post-COVID World. So, when we look at cross-border disputes, what it brings up from that is international arbitration, which is really the main mode of dispute resolution from a cross-border international sort of point of view. And we're going to infuse, elements of that with COVID-related issues. We are meeting in very difficult times. We can see that COVID is, the pandemic has lasted for a very long time. I mean, I'm wearing this jacket. I'm in the office here. In fact, it's only my second day back. We've been away for months. And getting into the office seems very strange, having to dress up, wear shoes and things like that. It really tells you the sort of impact that this has had on us on a very personal level, apart from the economic destruction that it has done around the world. So, just a quick few words about COVID. I mean, we're looking at a post-COVID world because we can see that things are slowly coming back to life, at least in Singapore. Other countries may be struggling a little bit more, but there's some movement around the world right now, to sort of bring back the economy to life. We are moving from a COVID to a post-COVID world. So just talking a little bit about COVID, you can see almost over 35 million people infected, more than 1 million people have died, projected to be 2.3 million by January 2021, which is quite depressing. And the huge impact that it's had on the global economy. I mean, it's been the worst recession since the Great Depression of 100 years ago. And you can see from the chart, from 3.3% growth in as late as January of this year. That was where the world was at that time. How it's now, contracted by 3% in April, getting even worse, 4.9% in June. So economic devastation. Next slide. If you look at Asia, growth is forecasted to slow to 2.2%. I mean, if you take it in a global context, it doesn't look so bad, but I think the projection was 5.2, so it's going to be quite a reduced level of growth. You can see from the chart how it's both the blue and the red lines, which includes just developing Asia, the red line, the other developing Asia excluding the NIEs. What the sort of forecast we have. I suppose the good news one would take out of this is that, at least according to the Asian Development Bank, this is we are set to grow in Asia by 6.2% from, of course, a much lower base due to the contraction. But still, it doesn't look so bad, I suppose, if you're looking at things optimistically. And I think we're looking largely at a China-led recovery. So that's why there's some room for optimism. Next slide. Singapore, is a very vulnerable country, and it's very responsive to global trends. If a few big economies get hit by something like this pandemic, looking at the US, Europe, China, and so on, it will affect Singapore in a disproportionately severe way. So look at the contraction in Singapore. It contracted by 42.9% in the second quarter of 2020. Unprecedented, far worse than anything we experienced in 2008, and far worse than anything I've experienced in my entire lifetime. It's just been, a complete devastation. Next slide. So from that, what does that mean in relation to the dispute resolution landscape? I think it's best summed up by Mr. V.K. Raja, the former Court of Appeal judge and Attorney General of Singapore, where he said, that he basically says that history tells us that in times of immense economic stress, disputes and litigation significantly increase. The COVID-19 pandemic, with its unprecedented impact on trade, markets, supply chains, and businesses, is likely to give rise to a tsunami of disputes. And he goes on to say that we are concerned about a legal epidemic. So from a health epidemic, it's now become legal epidemic, because we are expecting a lot of disputes that arise from performance defaults and insolvencies and so on. Our focus is, you'll see this in the local sphere, obviously, but our focus is, cross-border disputes for purposes of this talk, and this will arise from the global legal pandemic that we are likely to see, and how these disputes are going to be resolved. Now, we have in Singapore the COVID-19 Temporary Measures Act. So again, that's a Singapore-related issue. But even that act, carves out international arbitration. So if you want to pursue a claim in court, at the moment, you can't do that because of the Temporary Measures Act. But if you pursue a claim, I'm speaking very broadly. It depends on a few things like which sector and so on. But broadly speaking, the Temporary Measures Act makes it difficult for you to pursue litigation in the Singapore courts. But it does not apply to international arbitration. Arbitration has been carved out of the Temporary Measures Act. The other thing about arbitration is that, when we're looking at a pandemic or an epidemic, we're looking at solutions to how to carry on the process of dispute resolution. It's the unique features of arbitration that actually are best suited for that. So therefore, we thought this talk should be on that, because it represents a solution to the difficulties, barriers that you face if you're intending to pursue claims. Next slide. Just some overview on the, a couple of points about international arbitration based on the Queen Mary survey in 2018 is the sort of the gold standard in knowledge acquisition of what people think of international arbitration. So it's widely quoted, and you can see from that 97% based on the survey preferred international arbitration as a means to resolve cross-border disputes. So it's in terms of that cross-border disputes, people preferred international arbitration to other modes like, for instance, litigation. And you can see from the pie chart, cross-border litigation together with ADR is only 3%. Cross-border litigation by itself only 1%. So it's an overwhelming preference for international arbitration to resolve cross-border disputes. Slide. Please. Why is arbitration preferred? The survey reveals the main reasons for that. Enforceability is a big point, and I'll come to that in a second about how with international arbitration, you can enforce it in many countries around the world. Litigation is, if you've got a court judgment, it's more difficult to do that. So that's one reason for cross-border. In fact, it's the most significant reason for why international arbitration has been so successful as a mode of dispute resolution on a cross-border level. It's also designed to avoid legal systems and national courts. It has flexibility and so on. So confidentiality and so on. So these are the various reasons for why people choose international arbitration. Next slide, please. Now, what is arbitration? It is simply a dispute resolution process. It's a contractual process in which disputing parties choose one or more neutral third parties to make a final and binding decision resolving the dispute. In court, if you've got a dispute, it's the statute that brings you to court. If you've got a contract, you say breach of contract, it's the statute that gives the Singapore court or whichever court jurisdiction to hear your dispute. For international arbitration, or for arbitration, even if it's local arbitration, that arises out of contract. Parties agree to refer a matter to a tribunal, on a private basis to adjudicate and decide the dispute. And the competing modes, litigation, and there's mediation. I mean, the slide breaks it down so you can sort of see what the options are. So for arbitration, I mean, the main points are, private and confidential, the ability to choose your party. You can, it's the tribunal that decides the merits of the case. It's final and binding. For litigation, it's an open process done by a judge. There's no court fee. The judge decides the merit. It's not final and binding. Arbitration, the moment you concluded the matter, it's that. You can't appeal, at least in Singapore. Some places you can appeal on a question of law, but in many places around the world, and Singapore is one of them, you can't appeal an arbitral award. So, you can set it aside for breaches of procedure, but you can't overturn it on the merits. So there's finality with it. Litigation, you can go to a higher court of appeal. So there's no finality, but you have a second chance of, of trying to win the case. Mediation is different in the sense that you're trying to get people to settle the matter. And then what comes out of that is a settlement or a settlement agreement that binds the parties. So it's a different sort of process altogether. There's no adjudication. It is just bringing people to settle the dispute and enter into an agreement based on the settlement. Next slide, please. So it is the defining characteristics of arbitration that makes it so popular. Consensual, you need parties' consent to arbitrate. It's flexible, and it's final and binding. I mean, these are the qualities that people are looking for, and that's the reason why they go to, among the reasons why they choose international arbitration. So we'll just go through some of the main features, and the bullet points will show what they are. Next slide, please. For a start, the arbitration agreement, as I said, it's a creature of contract. It can be a specific contract, or it can be a clause in an underlying contract that refers the dispute to arbitration. It must be in writing. If it's not in writing, it must be subsequently recorded in writing. One way or other, there must be a written evidence of an arbitration agreement. Otherwise, it doesn't bind the parties in that way. There's no particular form, but there's a SIAC model clause which you can look at and use. And there's a number of features that a typical clause will have. It will firstly talk about a dispute that arises out of a contract. It will then say that dispute is referred to arbitration. It will then specify, the arbitral institution that is going to administer the case, in this case, SIAC. It will also specify the seat of arbitration, which in this case is Singapore, and I'll come to that concept later, the question of seat. It will specify how many arbitrators will constitute the tribunal. In this case, it's one. The alternative is three. It's usually one or three. It'll say what the language of the arbitration is, in this case, English, and what the law of the arbitration agreement is, in this case, Singapore. Now, based on contract, because it's a contract, very often you will have pre-arbitral steps that you will have to comply with. Typically, there would be in a cross-border contract, the need for senior management to negotiate the contract, negotiate a dispute, to come to a settlement. And failing which, you go to the next stage, which is usually that of mediation, failing which you will then go to arbitration. So these are the pre-arbitral steps that you have to go through, typically in a cross-border contract, in order for you to move towards arbitration. And in Singapore, these requirements, of satisfying the pre-arbitral steps, that is strict. It must be strictly complied with. So if your clause says that you've got 30 days to try to negotiate a settlement among members of senior management, if they specify, say, the general manager of both companies or the CEO of both companies, it's the CEO who actually has to do that. You can't sort of then, send your junior officer to do that, because that's not strict compliance with the clause. If you do not comply strictly with the clause, the tribunal may lack jurisdiction. That means if you try to attempt arbitration, the tribunal will not have jurisdiction to hear the matter. So you've got to go through the pre-arbitral steps, look at the contract and follow it very closely. That's a very, very important thing to do, particularly in Singapore, where the Court of Appeal has said it must be strictly complied with. The arbitration agreement is considered to be separate, a separate agreement as against the other provisions in your cross-border contract. And that concept of separability makes an arbitration clause valid even if the contract itself is not valid. So if you say the contract was entered into by duress, for instance, or if there was a precondition in the contract that was not satisfied, and you're arguing that, and in order for you then to sort of, and the other side disputes it, you can still take the dispute to arbitration, because the arbitration agreement is viewed as separate. So the precondition doesn't need to be satisfied in that way. You can go to arbitration even though you're saying the rest of the contract is invalid. In fact, you have to do that because it's only the tribunal that can finally decide whether or not it's valid and decide on the rights and obligations of the parties and whether there's liability and damages. Next slide, please. Now, this is where, I think, the part where, which sort of explains, very neatly why arbitration is so important in the context of the current pandemic. We'll go into the process later. I mean, with my colleague who will be talking about the arbitration process, but one of the things that arbitration is designed to do, it's designed to sort of find solutions that can be tailored. So, and that comes from issues of party autonomy. It comes from issues of procedural flexibility. So unlike court procedures, which are largely need to be followed according to statute, arbitration is bespoke. You can tailor your arbitration to suit your problem, to suit the environment, to suit the circumstances, which is why for issues of, like a pandemic and so on, it is actually the kind of thing you would need because of all the barriers that you might have, the physical barriers, the logistics barriers, and there's other things that you might need in order to find solutions to get your dispute heard. So the party autonomy means basically the parties has freedom of contract. Procedural flexibility gives the parties the right to choose various things like size, qualifications of tribunal, procedure for arbitration. You can have, for instance, virtual hearing or documents only arbitration because of the pandemic and issues like that, choice of law and so on. Next slide. I said earlier, and you saw the Queen Mary slide that showed enforceability of awards being the most important factor for the popularity of international arbitration. So the reason for all of that is the New York Convention. New York Convention has 165 countries that have signed up, and that means that whichever country you arbitrate in, you can enforce that award in any of the other 164 countries. And the country itself, obviously. So you have a full 165 countries to choose from, depending on where the assets are. So if you have a dispute with, say, a Chinese party or say a Filipino party, the arbitration is in Singapore. You hear that it's heard, you win. You can enforce your award in the Philippines and any of the other 164 countries in the New York Convention. So if the Filipino company has assets in China, you can enforce it there. If it's assets in US, you can enforce it there. For assets in London, you can enforce it there. So that's the magic of international arbitration. It is the reach of enforceability that makes it so popular. Next slide, please. The other, qualities that may suit your circumstances. Arbitration is a private dispute resolution mechanism, and as a reason, they are by nature private and confidential. In Singapore, if your arbitration is in Singapore, it's covered by law. The law tells you that it's meant to be private and confidential. Some other places it may not be. You have got to look at the law to see what it is. The rules of arbitral institutions can sometimes say whether or not it's private and confidential. SIAC rules is one of them, which makes it private and confidential. And many people want that simply because they don't want to sort of be embarrassed by litigation in front of a public, and that will happen if you go to court. It means that it's open. Anything that is said can be reported in the press, and you can follow the story, and all the allegations about what you've done in your company all will come out, and everybody gets to know about it. In arbitration, nobody gets to know about it. It's all done privately. So it's one reason why people who do not want to be embarrassed by publicity, they choose this mode of dispute resolution. Next slide, please. The one complexity of arbitration is that it involves a number of laws. It's the law of the contract. So the cross-border contract will say it's governed by, say, Singapore law, and then you'll have to look at Singapore law to decide the rights and obligations of the parties. There's the law that governs the arbitration agreement. So remember, an arbitration clause is separable, so it's governed by law which may be different from the law of the contract. There is the law governing the arbitration, which is the procedural rules that from the seat of the arbitration. So when it's the point about a seat of arbitration, when you say it's seated in Singapore, when you say it's seated in Hong Kong, when you say it's seated in London, it's the procedural law of Singapore that would apply, or the procedural law of Hong Kong or London that will apply. And finally, you have the relevant institutional rules like the SIAC. Apart from that, the other thing you need to know is that the rules of natural justice apply to international arbitration. And that has got two strands to it. The tribunal must be independent and unbiased. If the tribunal is found to be biased, it's a breach of natural justice that will allow a party to set aside an award. The other thing, other broad principle of natural justice you need to know is that there must be adequate notice and opportunity to be heard. So if you're denied that, that's again another reason to set aside an arbitration award or to risk enforcement of an award. Next slide, please. So I mentioned seat of the arbitration. So it's what they call the juridical place of the arbitration. So that's the place that cloaks the arbitration process in a certain legal framework, and that's the purpose of the seat. So, for instance, why it's important? It determines the law governing the arbitration procedure. It determines which local court has supervisory jurisdiction over the arbitration, and determines where the award is made. So, if it's in Singapore, you can then, because the seat is in Singapore, you can go to the Singapore court to set aside an award because the court has supervisory jurisdiction. You can go to the Singapore court in some situations to get an injunction because it's there to support the arbitration process and offer procedures to support the arbitration process. And where the award is made, because Singapore is a New York Convention country, you can then enforce it, as I mentioned, in the other 164 New York Convention countries. So that's why it's an important thing. It's different from the venue of the arbitration. Venue is the physical place where you run an arbitration. So, you could have your venue in any other country and still say your seat of arbitration is Singapore, because all you need to do is specify that clearly in the contract. For Singapore law to govern the procedure of the arbitration, that Singapore becomes the seat. So if you decide to go into a hotel room or a conference room to do your arbitration in Kuala Lumpur, you can do that as well. That's the beauty of arbitration. It offers so much flexibility. You can therefore, in the context of a pandemic, you can seat your arbitration in one country and then go to say a safe harbor, like a place like maybe Singapore or anywhere, Vietnam, places where there's very low infection rate, and you can very safely do your arbitration and still preserve the law of the seat. So you've got many solutions with international arbitration. That's the flexibility that it offers you. Next slide, please. So very quickly, what makes a good seat? When you choose your seat, according to the survey, what is important to most people is the general reputation and recognition of the seat, the neutrality of the seat legal system, and so on, track record enforcing natural arbitration law. Singapore it is very high up in this list. It's one reason why it's a very, very popular seat, because it has an excellent reputation. It's recognized as a leading seat around the world, very effective judicial system, very good arbitration law, very good enforcement and everything else. It's an efficient country, financial city, logistics is easy and all of that. So it's a very, very, good place to arbitrate. Other options, London, Hong Kong, and so on, I mean, they're all good in their own way. But Singapore has now become, I would say, the rising star in the international arbitration world, because it combines many qualities that other cities do not have. Neutrality, convenience, the level of efficiency, it has it's multicultural, all of that in an international world, all of that matters. And Singapore has got those qualities. Next slide, please. And that's the reason why at the moment, Singapore is now number 3, the third most preferred seat for international arbitration. We are currently number 3, but we are relatively new in this game. And yet we have become number 3. We're not far behind Paris, and London. I attended 1 year ago, Disputes Week in London, where they were talking about the sort of threats to London as the premier center for dispute resolution. And in that conference, they identified Singapore as the greatest threat to them, because Singapore is the one that is the fastest moving. Because of the rise of Asia, because of all the qualities I mentioned Singapore has, it's a true threat to London, you know, in attracting international arbitration to its shores. They're not so worried about Paris, they're worried about Singapore. So this is something for us to watch over the next few years. Next slide, please. I think I've sort of mentioned that why, you know, we have good legal framework, stable economic and political environment. Cultural diversity is a very important point. I mean, one reason for why people say that Hong Kong, for instance, you know, well, it is losing out in this competition with Singapore, you know, in terms of being the leading seat in Asia, is because it's a territory of China. So for some countries, take say a country like India, you know, going to China is a politically sensitive thing for them. So they would rather not do that and not choose that. Singapore has no such issues. There's no political sensitivity about choosing Singapore. There is no country probably in the entire world that has any issue with a place like Singapore. So that is one of the fundamental strengths that Singapore has that makes it a leading center for arbitration. Next slide, please. Here's some information about Singapore International Arbitration Center. It's Singapore's flagship arbitral institution. You know, it started in 1991, but it really only picked up speed, I would say, in the last probably 15 years. You know, so it's a fairly new entrant into this arbitration game, I would say. It's divided into various components. You have the board of directors, the SIAC Court of Arbitration, the Secretariat, and so on. Next slide. And here, just very quickly, you can see how the SIAC has grown. You know, from 160 cases in 2009, it's grown to 479 cases in 2019. No arbitral institution in the entire world has got this growth rate. It's so tremendous. You know, it is in the last 10 years moved up like 3 times. Next slide. So very quickly, it's it's broken down into the different types of disputes. The largest one being the corporate disputes, but it also has trade, there's construction, engineering, maritime, and so on, commercial. Next slide. So this is interesting because it tells you which markets feed work into Singapore. So in 2017, I mean, India was the leading one, followed by China, Switzerland, US, Germany. These 10 countries that are here largely appear in the, and you'll see in 2018, 2019, they're more or less the same. They're the main contributors to international arbitration. But note the US, because you'll see in the next slide. In 2018, US was the top, which is, again, this was very, it's unprecedented. The American companies, because of the power of the US over the years, very rarely leave their shores. They will insist on the seat of arbitration in the US itself. At most, they will go to, Europe or London or, a place like that. They wouldn't come to Asia. But because of the rise of Asia, particularly, I think, the rise of China, and the rise of Singapore and its reputation as being an international arbitration center, it has brought the US into the Asian arena. And Singapore has hugely benefited from that. As you can see, in 2018, US was first, followed by India, then Malaysia, China. Next slide. But I think the overall story is the biggest market we have in Singapore comes from India. And you can see that in 2019. Over the last 10 years, India has overwhelmingly been Singapore's best market, followed by China, I would say, and now maybe US is number 3. Next slide, please. So finally, on my side, is the ICC, which is the International Chamber of Commerce. Apart from the SIAC, the other leading chamber that has an office here is the ICC, which is actually the biggest arbitral institution in the entire world. And Singapore is in their top 5 seats. It's probably, they say, number 3 behind Paris and London. So, there are more ICC arbitrations in Singapore than there are in New York City. That's how well ICC is done here as well. And you can see that worldwide, according to the survey, ICC ranks as the number 1 institution. Now, I'm going to hand you back to Tiffany, but before I do that, I'll just explain that Following this, my colleague Jun Xiang will be talking about the arbitration process. So you'll see more of the COVID elements in play there and more details about the process. And finally, my colleague, who's the head of our construction practice in Singapore, John House, he'll be talking about force majeure, which is a very, very important issue, as you will no doubt know, and many of you will have questions on force majeure in the context of COVID. So they are to come. Now let me hand you back to Tiffany. Thank you very much.
Hey, and thank you, Prakash. Thank you so much for the wonderful presentation. And next up, we would like to have Mr. Ko Jun Xiang, Legal Director in Classes LLC. Jun Xiang's main areas of practice are litigations and arbitrations disputes, with a focus on shareholders disputes, employment, financial fraud, and regulatory investigations. He's also a specialist in insolvency and restructuring. So Jun Xiang, please.
Thank you, Tiffany. Next slide. So I'll be talking about the arbitration process and in particular the various stages of an arbitration. So for those of you who are familiar with the litigation process, in terms of structure, there's not a huge difference between an arbitration and litigation. Having said that, as Prakash mentioned earlier, one of the big benefits of arbitration is the flexibility that's built into the process. So as long as parties are able to agree, you can actually tailor the process in a way that suits your needs. It suits the needs of the case. It can suit the needs of the parties. It can also address issues that arise because of COVID. So, I mean, one of the things that people would want to do in the post-COVID world is to try and get resolution faster. So I'll come to some of the processes for expedited arbitration. You can actually finish an entire arbitration in 6 months. Whereas a court litigation, even in our hyper-efficient Singapore, we're looking at 1.5 years to 2 years for a typical court litigation. The other thing is you can have an arbitration that is entirely documents only. So your witnesses can just have their witness statements drafted in writing, and there's no need to attend for evidentiary hearing, which bypasses some of the problems that arise from COVID-related travel restrictions. Another point is that you can have the hearing that's entirely virtual. The arbitrator can be seated in one jurisdiction, you can be in Singapore, and your counterparty can be in China or wherever it is. And everybody just dials in and the arbitration can proceed on that basis. I mean, the court is also moving towards that direction, but it still is definitely slower than international arbitration to adopt a lot of these technologies that allow for a hearing to be conducted entirely virtually. Next slide, please. So I'm just going to run through the stages of the SIAC arbitration. I mean, the slides can and will be circulated after. So the step one is the notice. That's the commencement of the arbitration. There is a small filing fee of 2,000 Singapore dollars that needs to be paid to the SIAC to commence the arbitration. But in the greater scheme of things, that 2,000 is not a huge sum of money, and it starts up the arbitration. The notice itself should contain certain procedural points, like identifying the parties and a demand that the dispute be referred to arbitration. Next slide. So you have started the arbitration. Then 14 days after that, the respondent has to file a response. And when I say file, or when filing a notice or filing a response, all I mean is that it just needs to be sent to the SIAC by way of email. So everything can be done from your office. Everything is basically a PDF. It's just emailed to the SIAC or emailed to the other side. And the entire process can take place that way. So there's no need for a specialized system to access. The court uses an e-litigation system. There's no need for that. There's no need for fax anymore in the current world. And it's very uniquely suited towards a post-COVID world where there are travel restrictions, there are issues with getting hard copies to people, that kind of thing. Thereafter, the tribunal is then constituted. And Prakash also mentioned earlier that in an arbitration, you tend to choose either a single-member tribunal or a three-member tribunal. And the word to take note there is choose. You get to choose who your tribunal is. which means that you can actually select someone who is has specialist knowledge to deal with your case. So if you have a specialist construction dispute, you can actually get an arbitrator who is a specialist in the field and should then be able to come to a better sort of decision. Okay, next. Thereafter there'll be a discovery stage where parties exchange documents and then exchange of witness statements. After that, there's an evidentiary hearing. So what you would typically call a trial, if it's in court, in arbitration, it's just a hearing. Pre-COVID, you would get everybody into the room, either in a conference room in a hotel or at Maxwell Chambers, which is the Singapore dedicated arbitration facility. But now, increasingly, we're going to see a lot more virtual hearings. So whether it's through Zoom or one of these specialized platforms, parties will just dial in and conduct the hearing that way. After the hearing, which can be however many days that parties have agreed to, there are then closing sort of submissions. So your lawyers will then prepare written closing submissions, exchange that all over email. No need for specialist filings. And then the final award is drafted and issued by the tribunal. So even in the pre-COVID days, the one time that you would actually see parties in the same room together is the hearing itself. And now with developments in technology and the rise in popularity of virtual hearings, the entire dispute resolution process can take place without ever being in the same room as the other party or the tribunal, which again, post-COVID is something which would potentially be quite desirable in some types of disputes. Entire arbitration usually takes about 1.5 years to be resolved. Having said that, there are procedures which speed up the arbitration and also then lower costs. So I'm just going to go very, very quickly into some of these. Next slide. One of the procedures that you should be aware about and is available in arbitration is the availability of getting emergency relief. So arbitration takes a year, 2 years. What if you require something urgently? You have a shipment that has been delayed because of COVID. You need some sort of urgent relief, or someone is about to ship something out and you need that to be stopped immediately. You can go to court, obviously, and the court is there to grant injunctions and interim relief. But if there's an arbitration, there's also the availability of getting an emergency arbitrator. So you can actually just file your papers with the SIAC and they will start up an emergency arbitration for you to get the relief you want. So the best way to demonstrate this is through a case study. So I think, next slide. Just some statistics on emergency arbitration, the parties that use it and all, but next slide for the case study. All right, this is a case study that was for last year, and it was actually a case that we were involved in. So Friday after office hours, the claimant filed notice of arbitration and the emergency relief application. The very next day, 9 a.m., the emergency arbitrator appointed. By the end of Saturday, parties had conferred, agreed on a timetable for proceedings. Monday, response. Tuesday, witness statements. Wednesday, submissions. Thursday, hearing. So first 4 days of the following week, it was just back-to-back activity. Hearing took place by way of video conference. The arbitrator was seated in London and just dialed in. Exactly 1 week after the hearing, the award was issued. So start to finish, we are looking at something like 10 or 11 days from the time that it was filed, and remember it was a Friday night after office hours, to getting the award. So this is how fast an emergency arbitration can move. Of course, in circumstances where there's even more urgency, you can actually have it, even faster than that, back to back the next day. Anything can be done, and this is one of the flexibilities or the benefits of arbitration is provide that kind of flexibility and the ability to give you urgent relief. Next slide, please. Then there's also this expedited procedure under the SIAC rules. essentially what you're looking at is a 6-month arbitration. Start to finish, once the tribunal is up to the time that award is issued, 6-month time limit. It's a very, very popular application, or popular, not application, popular sort of procedure, because if you have a short arbitration, without necessarily compromising too much on the quality, you can actually get your result faster, and that tends to be cheaper for parties. Okay, next slide. The expedited procedure is, I mean, there's a lot on the slide, but the takeaway here is that parties can agree to it, or if the dispute is less than 6 million Singapore dollars, you can actually apply for the arbitration to come under the expedited procedure. Okay, then the sole arbitrator is appointed, and as I said earlier, it's a 6-month time limit. So it's quite a good tool for relatively low value disputes, and with not so complex issues in play. Okay, next. There's a case study there. So, I mean, basically what happened was there was a Thai claimant, Chinese respondent, trade dispute. Time between filing and rendering of the award was actually 7 months and 1 day. So that was filing. The 6 months actually starts from the time that the tribunal is constituted. So, but I mean, you give or take a little bit more. The constitution of tribunal to the rendering of the award was actually only 4 months. So there was actually a bit of correspondence in the start over getting the tribunal up. But once it was up, it moved pretty quickly. Okay, next slide, which I think is the costs. So at the end of the day, I mean, for a claim amount of about slightly above $500,000 Sing, the arbitration was only about 38,863, so slightly under 40. That's pretty cost-effective method of dispute resolution, I think. Okay, next. SIAC, and yeah, the third sort of procedure I want to talk about is early dismissal of claims and defenses. In court, there is the ability to get summary judgment. So you don't need to go to a trial if you have an open and shut case. Threshold is high. It must be really open and shut. It must be a very, very strong case. But the option is there. So for a long time, arbitration did not have that, and it was a bit of a problem because although if the other side was, wanted to drag you through an entire process and did not agree to expedited procedure, you would end up having to go through a year and a half. And one of the measures that the SIAC has put into place is this early dismissal procedure. So if you have an ironclad case, open and shut, you can actually apply for early dismissal of the other side's defense. Conversely, if you are the respondent, you can apply for early dismissal of the other side's claim. Okay. Next slide. Then the next few slides about joinder of parties and consolidation of arbitration. So again, another innovation that arbitration has had, and this is something which is was long overdue in our view. Court again allows parties to join suits up. If you have a multi-party construction contract, COVID hits, main con can't perform, can't pay subcons or whatever it is, the owner may be suing the main con may be suing the subcons, or subcons may be suing the main con. In court, you could join all those disputes up and have it all heard together. Arbitration for a long time had a problem in that regard, and there are now procedures for allowing for such joinder to take place. Okay, so in a cross-border situation, cross-border dispute where there may be multiple parties in the chain, say there's a trade dispute, shipment of goods, there were various middlemen down the line. Arbitration is now available and a way for parties to get all the disputes heard at the same time, which represents a cost saving, obviously. Next. So consolidation is a subset of joinder. It's about bringing in a separate arbitration and having them heard together. Next one. Okay, just closing off on some practical considerations apart from the procedures. Costs. So arbitration costs or the cost of arbitration has been an issue for parties historically. So as Prakash mentioned earlier, with the court, you don't pay the judge. In fact, you're not supposed to pay the judge. But for arbitration, you have to pay the tribunal. I mean, his fees come from the parties. So does that mean that the process is more expensive than court? Well, yes and no. I mean, obviously there is a layer of cost where you have to pay for the arbitrator. Having said that, it's not a huge amount. And with that comes the flexibility. So it's akin to buying a bespoke suit. The bespoke suit does tend to cost a little bit more than getting one off the rack, but it's not hugely significant. And there's a cost calculator on the SIAC website. We have put some figures on the screen where the difference between the panel of 3 arbitrators and single arbitrator. Okay, next slide. Okay, then in the post-COVID Singapore, I mean, we are aware that there's the COVID-19 Temporary Measures Act that's currently in place. It's expiring soon, so 20th of October is going to expire unless it's extended. I think a lot of us will know what the Act does, which is that it applies to certain types of scheduled contracts, construction contracts, hospitality contracts, events, tourism contracts, that kind of thing. And if you are within the scheduled contracts and you cannot perform your obligations because of a COVID-related event, the other side basically loses certain remedies against you temporarily. So it can't sue you, it can't commence a domestic arbitration against you. Having said that, international arbitration is carved out from the COVID Act. So if you have an international contract, international parties with an arbitration clause, and there's a non-performance because of a COVID-related issue, you can still commence arbitration. So that's something that needs to be flagged. The Act's coming to an end, but it may or may not be extended. We don't know. Okay. Next. Lastly, on practical considerations, and some of this was touched on by Prakash already, there are pre-arbitral, or sometimes you have to be careful before you start an arbitration, check your contract. Are there any pre-arbitral requirements that need to be met? These could be notice requirements. So you need to send out your letter of demand first before you can commence arbitration. Or there may be a tiered clause where you need to negotiate first before you start arbitration. And in Singapore, under Singapore law, such clauses need to be enforced strictly. Okay, so you have to follow it to the letter essentially. All right, so you have to be quite careful about starting an arbitration without having complied with these clauses. Mediation, we should probably, I mean, it's also a means of dispute resolution, and Prakash had mentioned it earlier. Mediation is different from arbitration and litigation, which are sort of adversarial processes. You're actually arguing against the other party, whereas mediation is more along the lines of parties reaching a settlement, negotiated settlement. And the Singapore's status as a mediation hub has been recently boosted. Last year, there was the Singapore Convention on Mediation that was executed or signed in Singapore. And what it does is that essentially it allows easy enforcement of mediation agreements cross-border. So mediation is increasingly going to be a popular choice. In the post-COVID world, I would venture to suggest that parties may be more inclined to sort of mediate, such that they recognize that, look, non-performance may be not entirely the other person's fault. It's not because they didn't want to perform, it's because of COVID. So yes, there's a breach of contract, but I want to continue doing business with you. So in this regard, mediation does present a pretty good option for parties to attempt, at least, before they get into a full-blown dispute. And it preserves the business relationship, allows further contracts to be entered into, that kind of thing. Okay. Finally, there is the SIAC has this mediation built into its rules as well through this ARB-MET-ARB protocol. Basically, it means you start an arbitration, you then stop it, go try mediation, and then you come back and continue the arbitration if it fails. Okay. Right. I think after that is next slide. Yeah. So I'm going to be handing over to John and back to Tiffany to introduce John. Thank you very much.
Okay, and thank you, Jun Xiang. Thank you for the wonderful presentation. Yep, and lastly, our final speaker for today is Mr. John House, partner of Clad & Co. Classes Singapore. John focuses on disputes resolutions and international arbitrations with a focus on projects and construction. He is the joint head of the Asia Pacific Projects and Construction Group, primarily looking at the firm's Greater China and Southeast Asia practice, and has worked in Asia since 2000. So John, please.
Well, thank you very much, Tiffany, and good afternoon to everyone. I'm about to attempt the impossible, because what I'm going to cover with you now is probably about 3 hours worth of material. And I'm going to try and do it in 10 or 15 minutes. All I can do really is give you some very, very general guidance in terms of the types of problems and the types of solutions that you should be looking at when you're looking at COVID-19 problems. And I'm focusing on the area where I work, which is construction, engineering projects, oil and gas, that kind of thing, big built facilities. So what are the types of problems that we're seeing all over the place? Well, it's interesting, actually. The first problem that we saw right at the outset when this all started to emerge around Chinese New Year was plant and equipment coming out of China, and one of the big problems is that there are an awful lot of construction materials and construction plant that comes out of China. Pretty much all of the tunnel boring machines that are used to build the MRT projects and all the other big projects in Singapore are made in China. And around about February last year, there were big problems getting this stuff out of China. Things are getting a little bit easier now, but that was the first problem to emerge. Another problem which emerged more slowly perhaps, but is now becoming much more of a greater problem, is movement of staff. It's really hard to move people around at the moment. You can see behind me that there are hills, and the reason that there are hills behind me, and there aren't many hills in Singapore, is that I'm in Hong Kong at the moment. Because I had to come here on business, and I'm waiting to get back into Singapore. I may have to do quarantine, but I'm hoping that green lanes will open up and I'll manage to avoid that. But it's very difficult now to move staff around, particularly between countries. And of course, the other problem that we're seeing on construction sites and also in the office environment is protective measures at the workplace, social distancing, increased measures like disinfecting staff, having to quarantine people, that kind of thing. So all of this is causing problems. It's either stopping projects altogether and making it very difficult to perform, if not impossible, or it's increasing costs and delaying projects. So these are the types of problems that we're coming across. Next slide, please. So what are the sources of relief that we need to talk about? There are really two things that you need to think about when you're analysing a problem. There are some general legal principles which you can look at, and there are also specific clauses in your contract. So there are the two things that you need to look at. Do any of these specific principles help me, or are there any specific clauses that help? Next slide, please. So the three principles that I'm going to talk about: force majeure, which is probably the biggest one, impossibility and frustration. Now, impossibility and frustration I'm going to spend less time on because they are less common and probably more unusual, but I'm going to talk more about force majeure. Next slide, please. Now, I've taken here the definition of force majeure from the FIDIC Red Book. Now, the FIDIC Red Book, for those of you in the construction industry may know, the FIDIC suites of contracts are the internationally recognized contracts that are used around the world in construction projects. The FIDIC Red Book is probably the most commonly used for a traditional form of contract. And this is the definition of force majeure in the FIDIC Red Book. And it's a pretty typical definition. So it defines force majeure as an exceptional event or circumstance which is beyond a party's control, something they can't have, that they couldn't have controlled, which they could not reasonably have provided against before entering into the contract, which after it had been arisen, the party could not reasonably have avoided or overcome, and which is not substantially attributable to the other party. Now that's the FIDIC definition of force majeure. And then what the FIDIC contract goes on to do is to deal with the circumstance of what's the effect of a force majeure event on the contract. And what the FIDIC Red Book provides is that your excused performance, and you can suspend performance for a period, and you're not subject to any penalties while that's going on. And if the force majeure continues for a long enough period, you can bring the contract to an end. But the key thing to understand about force majeure in a common law jurisdiction, and by common law jurisdictions I'm talking about England, Singapore, Hong Kong, Australia, America, South Africa, all the places that have effectively used English law as their route. If you're dealing with a common law jurisdiction, force majeure is a creature of your contract. So if you do not have a force majeure clause in your contract, you cannot rely on force majeure. So you have to look in your contract to see if there is a force majeure clause, and particularly if there is, whether the situation that you are dealing with falls within the force majeure definition in your contract. Most of the forms of contract you see in Singapore contain a force majeure clause, and most construction contracts do. But you need to look very closely, and if you do, then there will always be notice requirements and things that you need to do to bring yourself within the provisions of the clause. Not time to cover it now, but if you're dealing in some of the civil code jurisdictions, some of the Middle East jurisdictions, I think China as well, there you will find force majeure as a creature of the civil code. So even if even if force majeure is not in your contract, the civil code may come to your help, but that is not the case for contracts which are common law contracts. Next slide, please. Now, I'm not going to spend long on this route to relief because it is less usual, but it is worth looking in your contract to see if there is an impossibility clause. And certain contracts, where I am at the moment, Hong Kong forms of contract tend to have an impossibility clause in them. The FIDIC Red Book has an impossibility clause in it. So what an impossibility clause will do is, if something happens which makes it impossible or illegal for either party to fulfill its contractual obligations, then they're excused performance. You will sometimes find them in contracts. If there is an impossibility clause in your contract and your contract has genuinely become impossible to perform, then you may look at the impossibility clause. If there is no impossibility clause in your contract, though, bad luck, because in common law, at least, impossibility of performance is not an excuse. If it becomes impossible for you to perform your contractual obligations, then you are still liable, and you're still liable in damages for that failure to perform. Next slide, please. Now we're now on to the final of the general remedies that I talked about, and that is the doctrine of frustration. Now, this frustration is not a creature of contract in this sense that you don't have to have a frustration clause in your contract for the doctrine of frustration to possibly apply. There are some contracts that actually do have a frustration clause in them, but it doesn't have to be in the contract. And again, I could spend 20 minutes talking about frustration, but I'm not going to. But if you've got a contract where the circumstances have changed so dramatically that it is no longer possible to perform what you're doing because what you are going to have to do under the contract has been changed so completely that it's something completely different, then the doctrine of frustration may apply and get you out of the contract. It's quite rare. I haven't come across a situation in COVID, and I've only come across one frustrated contract in my professional career, but it is possible. But it would have to be a complete change in what the nature of performance was going to be. If, for example, you were building a stadium for a sporting event and the sporting event was cancelled so that there was no longer any need for the stadium, it might well be that you might end up there in a situation of frustration. So you've got those three potential remedies that I've talked about: force majeure, which is likely to be your main source of relief; impossibility, less frequent; and frustration. But the other area, and probably a major area to be looking at, is specific clauses in your contract which may allow routes out of performance, and may enable you to deal with situations where you're prevented from performing, or you're incurring additional cost. And I've just put a couple of these in. On the next slide, I've put again an example, I think, from the FIDIC FIDIC Red Book, which actually applies to an epidemic situation where a contractor or a subcontractor who is engaged in a construction contract comes across a situation where it's prevented from performing because of unforeseeable shortages in the availability of personnel or goods caused by epidemic. So there's a clause which would excuse performance. I put one more in on the next slide, which again is from the FIDIC Red Book. And this is, I think, another fruitful area to look at, where there is a provision which allows for an increase or a decrease in costs resulting from a change in the laws of the country, including new laws or the repeal or modification of existing laws, or even the judicial interpretation of laws after the date the contract has been entered into. So I know a lot of the clients that I've worked with in Singapore where they have had difficulties because of regulations regarding bringing people or goods into the country, have been able to rely on clauses like this to excuse performance. So that was a very, very quick canter through the sorts of things that you need to be looking at if you're looking at situations arising as a result of COVID-19. Force majeure would always be, I think, the first starting point, but worth looking also at the concepts of impossibility and frustration, but also looking at these specific contractual clauses dealing particularly with things like change of law, shortage of goods and materials, and that kind of thing. And that, I think, is about all I've got time to talk about for now in relation to COVID-19 problems. Thank you.
Okay, and thank you, John. Thank you so much for the presentation. Now, before we're going to start off with the Q&A session, for those who would like to receive the presentation deck, we will be sending it to the participants who have attended the webinar session today after the event. Now, let us welcome back our three speakers for the Q&A session. Prakash will be the moderator for the Q&A session as well. If you have any questions for our speakers, feel free to submit them by clicking on the Q&A button at the bottom of the screen and type in your questions. Do note that as we have limited time for the Q&A session, we will not be able to answer all questions. Thus, we seek your kind understanding that should your questions not be able to answer during this session, please contact Clark & Co. Classic Singapore directly with their contact details featured on the screen, or email SCCCI, and we will forward your inquiries to them too. Now, we would like to hand over to Prakash. Prakash, please.
Yeah, thanks very much, Tiffany. Yeah, welcome. Well, I'm welcoming myself back. It's very. It was. I hope you found this presentation to be very fruitful. And thank you, my colleagues, for your excellent presentations as well. It was, very, very nice hearing from both of you. Now, we've got time, as Tiffany was saying, we have some time for Q&A. There were a couple of questions that have come through. Let me just take the first two, which are actually quite straightforward, before I start posing the more difficult ones to my colleagues. Well, the first one is, I have a dispute with my vendor who's based in overseas, and the total cost of the website service is less than 10K. Should I still go through arbitration or mediation? Now, arbitration, there's a question many people ask about arbitration in the context of low value claims. Arbitration, generally speaking, I would say, doesn't really suit low value claims, particularly not in the region of 10K and things like that, because by the time you pay your tribunal and the arbitral institution and the council and everything else, it's going to way exceed that 10K. So the better thing to do for low value claims, particularly in a cross-border context, is to try to get them settled. Mediation is certainly an option, but even then you've got to pay the mediator. But I mean, if you can find a fairly affordable sort of mediator and split the costs and so on, that is certainly an option. Otherwise, you negotiate a settlement and you hope that that works. But arbitration doesn't really lend itself to very low value claims. Second question is, what if the defendant refuses to participate? Arbitration can't give a default judgment. That's true. Arbitration cannot give you a default judgment. Ironically, if as Jun Xiang mentioned, under the SIAC rules, if somebody files a frivolous defense, you can actually strike it out and sort of enter judgment, because now the rules allow you to do that. But if you don't turn up, if the respondent doesn't turn up, you can't. There's no mechanism to enter a default judgment. It's one of the features of litigation which arbitration doesn't have, because of the the right to be heard and all of that. So what you would need to do is proceed with the arbitration. Typically, when it's quite clear the other side is not turning up, the arbitrator will tend to speed things up, and it becomes I would say a very very fluid sort of process, in the sense that the timelines will flow very quickly and you will reach your conclusion much more quickly. But you still have to, this is the important point here, you still have to prove your case as the claimant. So the tribunal still has to listen to your arguments. And as claimant, you've got to establish that on the balance of probabilities, you have established liability and damages for the tribunal to give you your award. So it doesn't work the same way as in court, where you can just enter a default judgment and seek to enforce the judgment. Okay, so that's that. Now, let me invite John now, maybe to sort of take one of the questions that's come through. One question is, how do we mitigate cross-border disputes, that are caused by COVID-19? So I think you mentioned force majeure and impossibility and so on. I will tie that into another question, which is a specific example of someone who's, supplied ship equipment to an Indian shipyard, and as part of his contract, he's got to commission that, and he's got to send staff over there. And because, in India has got the second largest number of cases in the world after the US. So, understandably, people are reluctant to go there. So can you offer some solutions there, maybe along the lines of what you're talking about, force majeure or impossibility or possibly frustration? John.
Okay, well, yes, thanks, Prakash. I'll go from the, if I may, from the general to the specific. What I would say generally in relation to mitigating claims is, first thing, you must know your contract. And I always say to my clients, look, sit down, look at the contract and make sure you understand the whole thing. And particularly, often there is more than one clause that's helpful. And it may be that some clauses are more helpful than others. So, for example, you may have a force majeure clause, but often a force majeure clause will enable you to excuse performance, but it won't get you money. If you're a contractor, it may simply say, well, look, you're excused performance for however long the force majeure goes on. There may be another clause that perhaps might deal with change of law, for example, or shortage of materials, etc., which will give you time and money. So have a look at your contract in the round and make sure that you know that, and you know the best clause that you can go under. Point one. Point two, operate your contract. Very often, if you're dealing with a force majeure or any kind of contractual claim, there will be notice provisions, and there may be time limits and those sorts of things, and you've got to make sure that you claim any relief and you do anything that you need to do to entitle yourself to relief. Third tip is manage your supply chain. In construction contracts, there are always long supply chains of subcontractors, suppliers of materials, etc. Very often the contracts are not back to back, and you may find that you've got a situation where supposing, for example, you're a main contractor, you've got a supplier who's providing you some equipment that's coming out of China. That supplier has got some difficulties, and your contract with the supplier may not be on all fours with the contract that you've got with the employer. You've got to look at those contracts, you've got to look at alternatives, and you've got to actively manage your supply chain. So those would be my 3 tips. Looking at that specific circumstance, I think that about people going to India, I think there you would have to have a very close look at the contract. It may well be that there is a force majeure clause that enables you to escape that liability, because clearly when I'm assuming that the contract was signed before the COVID situation developed, having people travel to India to commission something would have been something which was very, very run-of-the-mill when the contract was signed, but is now in a position where actually it would be highly difficult to do. So it's hard to advise without the contract, but have a look to see if there's a force majeure clause. Have a look also to see if there are any clauses that enable, that are more specific. There may be issues around supply of labour or what have you, where you can escape liability. And also, I don't know if there's anything in, I don't know what law the contract would be subject to, but if it's subject to Indian law, there may be some local provisions that would help you. But have a very close look at your contract, see if there's anything that will help you in that contract, and engage with the sponsor, with the owner, just to talk about alternatives, to see if there's other ways that you can deal with the situation. Thank you.
Thank you very much, John. Jun Xiang, a question for you. Does the Singapore government have any provisions, and I think it, by that he means, or she means, legislation to protect companies that have cross-border contracts during this COVID period? I think you touched upon the COVID-19 Temporary Measures Act. Maybe you can sort of outline some of the features of that in relation to cross-border contracts.
All right. So thanks for that. As I mentioned earlier, I mean, Singapore has the COVID-19 Temporary Measures Act in place, at least up to the 20th of October. The Act applies to types of scheduled contracts, so construction contracts, tourism contracts, that kind of thing, and it's all scheduled in the Act. It doesn't matter whether those contracts are cross-border or not. So if you are the Singapore party who is obliged to perform one of those contracts, and you are materially affected by COVID-19 or event that is caused by COVID-19, for example, a change in law, travel restrictions, then the other side can't basically enforce those contractual rights against you during this period of the Act being in force. It doesn't cancel the obligation, so it doesn't mean that you get off scot-free or you no longer have to perform the obligation. It just means that until the Act is no longer in effect, you can't be basically sued for non-performance of those obligations if the non-performance is materially affected or caused by COVID. So there are some protections in place, but they are temporary and they are coming to an end. And as mentioned earlier, it doesn't prevent international arbitration from being commenced. So you have to look at your contract to check whether it's an arbitration clause or a litigation. You will also have to start making, given that the deadline is coming up soon, you will also have to start making provisions as to what you are going to do post the ending of the Act. Yeah.
Okay, thank you very much, Jun Xiang. I don't see any more questions. Anyway, I think we are rapidly sort of running out of time. Now, if you have any follow-up questions, our emails have been sort of flashed up there somewhere. Please follow up with us. We'll be very, very happy to hear from you. We'll be happy to keep in touch. Reach out to us. We can't sort of see you here, but you can see us, and you know where to find us. So please, don't hesitate to get in touch. So with that, thank you very much on behalf of my colleagues. Thank you all very much, and it was a real pleasure, speaking to you. And we'd really like to thank the Singapore Chinese Chamber of Commerce for giving us this opportunity. I'd like to hand you back to Tiffany. Thank you very much.
Thank you, Prakash. Thank you. As what have Prakash said, for those participants who may have very lengthy, detailed questions that we are not very convenient in posting up on the Q&A sessions, rest assured that after the event, SCCCI will be sending you guys an email with the contact details that you guys can email Clark & Co. classes immediately. Okay, so once again, we'd like to thank all the participants, and a big thank you to Prakash, John, and Jun Xiang for their time and valuable sharing for today. And we hope that you have benefited a lot from the webinar sessions, and we look forward to seeing you again in our future events. So stay safe and stay healthy, and thank you and goodbye. Thank you very much.